Hi, everyone. Thank you for joining us today for Constangy's webinar, Union Resurgence, Navigating the Tidal Wave of Organizing Under New Ambush Election Rules and Cemex Bargaining Orders. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave time to answer your questions. This program is approved for SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I am now going to turn it over to today's presenters, Tim and David.
All right, thank you very much for getting us started this morning, or I guess this afternoon for everybody, unless you're coming to us from the West Coast. David and I, my name is Tim Davis. I'm a managing partner, and David and I are both we dedicate our practice to labor law, which has been kind of a roller coaster ride the last year or two, so to speak. So I'm going to really quickly do a few introductions. As was mentioned already, we are going to try and take questions in the context of the presentation if we've got time. We will also stay on and answer questions afterwards if we need to extend it out in the interest of everybody who I know probably just set aside an hour. So we are going to move this through very quickly. Our plan is going to be that David is going to spend about half our time covering all the technical legal changes that have occurred, most of them in the last year. It took the Labor Board a while to ramp up all their efforts to get the legal process going and the rule change process going. So a lot of these have occurred in the last year. And then I'm going to spend about the last half an hour talking about practice, best practice, ideas and ways to start dealing with what David's dealing with. So this is who we are. I think mostly this was reserved for clients, but I know there are a lot of non-clients on it as well. Quick thing about us will be in there. My bio's in there as well as David's, if you do want to reach out to us. Our contact numbers are here, and we will get these out to you again at the end, because if you do have questions that you need answered and don't want to do it in this context, we can also just take emails later on as well. So with that in mind, welcome to the webinar, and I'm going to turn it over to David to spend some time covering all the crazy legal stuff that's going on.
Great. Thank you, Tim, and welcome all. Yes, so today we're going to talk about the National Labor Relations Act. It is a law, but much of what goes on underneath the law is politically influenced and is not what you'd call pure courtroom law. Many of it is subjective decision-making based on who's in power at the National Labor Relations Board at the time. The law itself has protections for concerted activity of employees. Employees is defined rather narrowly as non-supervisors, generally for lay people, and so managers typically are not within its scope, except for special circumstances where the actions taken with respect to managers somehow influences the underlying employees. It also protects the right to collective bargaining, right to strike, and the NLRB, the National Labor Relations Board, was a body created to interpret and enforce the National Labor Relations Act. The board, as I said, interprets the law. It's become rather political in recent years, where the majority oftentimes will flip and reverse decisions that were important to employers under prior operations, and they have to switch because of the labor board change in majority status. Right now, President Biden has appointed the majority of the board. He indicated he wanted to be the most pro-labor president in history, and he is, at least his appointees are doing it, although at least theoretically they are supposed to be independent of the executive branch and are not supposed to be doing the president's bidding. There's a current case filed by SpaceX that's challenging the very structure of the board because of its essentially because of its political nature and the structure of it, where the board itself acts as prosecutor and adjudicator in certain circumstances, and there is no right to a jury trial under the National Labor Relations Act as it currently exists, based on decisions going back about 70 years when the act was first produced. People challenged its constitutionality, and almost all the objections to it failed. So here's the current constituency of the board. We've got one vacant Republican seat and one lingering Republican at the top of the screen. You'll see here, appointed by President Trump originally, and then we have three others. Chairperson McFerrin at the bottom has stayed on as a Democratic member. There is a general consensus, not changed over the years, that whoever the president's party is can have 3 seats, and the non-presidential party gets 2 seats. And so right now we have 3 Democrats in control. The general counsel is a very special position under the structure of the board. She, like the 3 Democratic members, all have union side experience, essentially no employer experience, or no consideration of the employer's business circumstances. And unlike many of the federal government agencies, the general counsel really is not the legal advisor to the entity or the department. She is essentially the prosecutor, and her department and people under her prosecute the law with her interpretation of the law, trying to bring it forward where she thinks decisions may have been wrong in the past. She can bring her own stories to the board to see if they will approve it. Next slide, please, Tim. So currently going on is a major major thrust to change the law, coming both from the general counsel and the majority through decision making and regulation making. And here is the list of some of the things going on that are, we in the practice would call big deals. And so at the top of this is Cemex, which we'll talk about in a moment. New ambush election rules have just come into play. They revert to regulations that were in place during the Obama administration that essentially fast track elections. And so typically what employers have happened is they suddenly know they have a union organizing campaign that's been going on under the surface. And so time is typically on the employer's side to come back with what their story is. And so the ambush election rules shorten the time down, so there's very little time for the employers to tell the story. That's what the board wants with their new regulations that just came back into play. The Trump administration appointees had put it back on a slower track. Another case that shifts back and forth is micro units. It generally, you may be, as mostly lay people in the audience, you're generally familiar with what we think of as wall-to-wall units, that a factory or a warehouse or a plant or a restaurant may be unionized in scope. Well, oftentimes there could be small groups within a larger group entity where a union will come in and try to organize just that group, with a famous one being a shoe department at a Macy's store or some other department store in a big city. Can you just organize the shoe department? A lot of people say, well, that doesn't make sense, at least under current law. With the current board majority, micro units are acceptable, absent overwhelming community of interest principles that other people essentially have to be included, or it doesn't make sense. Looking to the future, historically, employers have been allowed to call employees into meetings during union campaigns and telling their story and requiring them to be there. The current general counsel doesn't like that and is pushing back on that, looking for a new decision. A recent decision got close to it, but didn't. They passed on the chance to decide that question. Email access, again, could be coming. Unions have argued that since employers use their email for talking to their employees, that they should be allowed to, that employees should be allowed to use them also for unionizing purposes and other concerted protected activity. Another case that's a little tricky is that employers sometimes will, in their campaign materials, tell employees how the status is going to change of operation of the employment relationship. And oftentimes employers will state something to the effect of, this will bring a third party between you and us. And the current general counsel is fighting against that, saying that's a misrepresentation of law because the act specifically allows employees to bring grievances to their employers. And without getting into nuances of direct dealing, the general rule is once you have a union in place, for terms and conditions of employment discussions and bargaining, you have to go through the union. Last is a case dealing with permanent strike replacements. In strike situations, at least historically, the board and courts have recognized that it's an economic power situation, that there's not supposed to be an outcome determinative result under the law, but the law is supposed to equalize bargaining power. And part of the equalization has been that if employees don't want to work and they strike for economic reasons, employers can resort to their economic power to hire permanent replacements. Tim, next slide, please. So Cemex is a very recent case. The slide sets out some of what's going on here. Some of you may have been through it, but a union often will go out and get support either in cards or in a list of people who support the union, and they'll have signatures and they'll present it to the employer and say, we represent your workforce, please bargain with us. And at least historically, employer advice typically was, we don't want to see your list, we don't want to see your cards, go to the National Labor Relations Board and get an election if you have the right to have an election, if people really support you. And there's a big change going on now from the Cemex decision. It's under appeal, but the board has ruled that when presented with a demand for recognition by a union, the employer has 14 days to consider it, and they have to file their own representation petition, which is here marked as an RM petition, or they will be required to bargain with the union that presented the demand letter, with one other caveat that if the employer commits an unfair labor practice that makes a fair election impossible in the eyes of the current board majority, then there might be no election whatsoever, and a bargaining order can be issued without giving the employees ever a chance to vote. And there are a number of questions unanswered by Cemex. The general counsel put out a memo of her interpretation of all the unanswered questions. And as you might expect, almost on every issue, it goes the union way in filling in the gaps. And for instance, what happens if the presentation and demand for recognition is a completely fictitious unit or a unit that makes no sense? One employee, two employees within a department. That can't make sense. What's the employer to do? Who do they recognize? Are the signatures valid? All those things are very unclear at the current stage, but at least in the general counsel's determination, the union is always right and the employer typically is wrong. Yeah, the presentation could be to any supervisor or managing employer agent. So it's important that all employers counsel their management force to be on the lookout for this type of thing so that they can act promptly, because if you sit on it, the rights are waived. Okay, next slide, please. And here this somewhat speaks for itself as to a bargaining order. I think what most of us in the practice on the employer side expect is that when given the opportunity to issue a bargaining order because of unfair labor practices by an employer during a union campaign that at all taint the potential for a fair election, you have a good chance of seeing a bargaining order. Historically, there was what was called Gissel bargaining order, which was where the employer had done things that were so outrageous that the circumstances made an election impossible, even a rerun election. Okay, next slide, please. Okay, I mentioned this briefly before. This came as a result of new regulations that were essentially a repeat of regulations during the Obama administration to give time under the Administrative Procedures Act. The board did this in the fall and made the effective date the day after Christmas, December 26th. The shorter election period now is probably at most 21 days from the date that the employer sees the petition. Under the old regulations, it could probably be about 35. It would be subject to much more discretion on what makes sense in the workforce location where the people were going to be voting. Now, the board is going to take a fairly rigid view that you can't go past 21 days. We're going to have an election that fast. Part of the problem here is the speed with which all this happens. Again, it comes as a surprise to the employer when they get a petition. Even if they are the one that files an RM petition, things will happen fast. Notices need to be posted. I'll use the word immediately, but within 2 business days on occasion. Unit lists of employees and positions need to be listed and presented to the board. A position statement needs to be presented to the board by noon the day before a hearing occurs, and the hearing is going to occur not later than the 8th day after the petition is filed. And then you have to have voter lists done. And so for a small group of, say, 11 employees, that might be easy. For a factory that has 2,000 or 3,000 employees, it's a very hard thing to do all the informational requirements as fast. It's a full-time job for several admins, lawyers, managers, etc., to do all that the board thinks is easy for the employer and requires. Next slide, please. So here is what a typical timeline could be. I won't spend a lot of time on it here today, but you can see the various steps that go through and how fast things are happening. Simultaneously with this, at least in theory, most employers would like to be communicating with their employees about what unionization means, what it might mean, what the economics of the situation are in the current economy, competitive forces, etc., in their business. And this all has to go on simultaneously to communication of the message, and it's very fast. Next slide, please. Okay, so mentioned this earlier as well. Micro units. Generally, the rule is now, under the current board, reversing a decision of a Trump-appointed board majority that indicated larger units were needed that made more sense. Here, at least presumptively, a petition for a unit will be appropriate as long as it's a readily identifiable group. So for instance, a department could be, a location could be, and it's then up to the employer who objects to that unit to show that there's an overwhelming community of interest with people excluded from the unit. Otherwise, the petition for a unit goes. And it used to be that there was opportunity for hearings and much more discussion in the settlement process. The other thing I didn't mention earlier is normally what the board agents want to do is not have a hearing if they can get out of it by doing a stipulation for an election. You pick a date, you describe the unit, you describe who's excluded from the unit, and everything then just is a campaign. If that doesn't happen, there used to be some fights about various issues. Now, most of those issues are gone until after you have the election. So the petition for a unit typically will go unless you can show an overwhelming community of interest that people need to be included. And typically that would require something like employee integration. And take the shoe department example, are there substitute people from other departments who regularly come in each day at lunchtime and run the shoe department while the shoe people are away? You might have a good argument that those substitute shoe people ought to be part of the unit, and therefore wherever the substitute unit, their department ought to come into. So here's some examples that have historically come up of what we call cherry picking. And usually a union, if they don't think they can get a wall-to-wall type unit, they will go for their key support group and get that first to get what we call a nose under the tent. So this, as I mentioned before, is under attack. Normal campaign strategy would be to make sure that employees know what the company's position is and know some facts about unionization and hear it from both sides of the election equation. And here, the current general counsel considers it to be inherently interference to force people to come hear messages, and that she considers one of the right to considered protected activity not to listen. And so that's their theory. That's what's going on. It includes one-on-one meetings where an employee essentially can't move away and can't get away from the discussion with the supervisor, which is another technique that employers typically do, to have employers go out through their supervisors and communicate to the employees and tell the employees what the company's position is and why a union might not be in the employee's interest, and explain some of the facts. There is a recent case where the board passed on it, as I mentioned. It involves Starbucks. The general counsel wanted the board majority to rule that the discussions with an employee were unlawful interference and to outlaw captive audience meetings. The board did not pass on that, and on the facts of the specific case found that the employee had agreed to hear the employer's message from a supervisor, and therefore the statements made in that case were lawful and not interference. As far as one of the issues in campaign content that also is under attack from the general counsel is an often communicated message by employers that a union coming into the workplace will change the relationship, and there won't be an open, what's often is generically referred to as open door policy, that the employer likes an open door policy. We like dealing directly with employees, and why should we put a third party in here that would limit your ability to come to us? And the general counsel is taking the view very broadly, based on at least one section of the National Labor Relations Act that does say that employees have a right to bring grievances individually to their employer, that any misstatement of the law itself to employees in the context of a union campaign is coercive. And there are situations where employees can in fact come directly to employers that aren't what we call direct dealing. And so there's a line of unfair labor practice cases where if you have a union in place, and an employer deals directly with employees, sometimes it's characterized as circumventing the union, sometimes it's characterized as direct dealing. That's all unlawful because you're not going through the lawful representative of the union. Here, there's an old case back from 1985 that found that this type of language was lawful. The current general counsel wants to change that. She did, a department under her jurisdiction within the National Labor Relations Board, which is called the Office of Advice, issued an advice memorandum that gave examples of the kind of things that will be unlawful if her interpretation of the law is adopted by the majority of the National Labor Relations Board in a case. And we mentioned this briefly before as well. In general, again, economic power has always been the lay of the land when it comes to strikes and strike replacements, at least in economic strikes, in contrast to unfair labor practice strikes. In unfair labor practice strikes, you cannot permanently replace people on the theory that they didn't want to work. The reason they're not working is in protest of the unfair labor practices, is at least the theory of the National Labor Relations Board. Here, the current general counsel would like to go one step further, that you can't permanently replace economic strikers because it inherently is a threat against their coming back and impairs their ability to strike. Then another topic which some of you probably have heard about or read about because it's gotten a lot of comment in the news, is the even today. The National Labor Relations Board has implemented or issued a new set of regulations on joint employment, and it vastly increases the range of employers and employment relationships that will become joint employment, as opposed to be what used to be separate employing entities. When they issued the regulations in the fall, they failed to allow the full 60 days of notice to both the Senate and the House of Representatives of the new regulations that's required under an administrative rule. And therefore, they had to kick it back to February 26th. And therefore, these are coming. Employers need to be ready because it complicates greatly any actions and communications and potential liability for employers, because there may be separation from the actions and the information from the penalties that the National Labor Relations Board wants to assess, and from the responsibilities that the National Labor Relations Board wants to put on employer if there's a joint employment situation. And so, going back to when we talked about the quick timeline on quickie elections, here, this could be a nightmare, because employer has a certain number of days to get in the voter lists. It doesn't even know who the employees may be at their temporary employer contractor, who they're working with, who they're just being found to be a joint employer with. Same thing for unfair labor practices. They may not know all the conduct of a joint employer whose supervisors aren't doing the right thing, where you as an employer are trying to obey the law scrupulously, yet you're going to be held responsible as a joint employer potentially for the unfair labor practice. This is going to affect primarily relationships such as subcontractors and general contractors, franchisors and franchisees, temporary or contract workers, and other employers where there's not a direct employment relationship. And the board's expansion of the concept, I'm trying to remember the exact language, it's essentially, even if you do not have direct control, it's the potential for control, the potential ability to control the relationship that will be what the board will be looking at. Next slide, please. So with that in hand, and with, say, 2 years or so of the current majority in place and the current general counsel in place, and unions knowing that the playing field is in their favor right now, what we've seen is unprecedented union organizing. And you see a lot of it in the news, where major companies are facing either their first union losses or huge organizing campaigns, either directly union campaigns or simply publicity campaigns about them. Usually their message is focused on the economics and often targeting the high salaries of the executives of companies and the wage disparity, looking at various demographic groups and trying to separate the various demographic groups to get support within them, with often a focus on younger workers. Recently, the UAW, you've probably seen, has done new contracts with several of the Detroit automakers, and they now want to push to the non-union automakers that are essentially the European and Asian automakers in the United States that are unorganized. And they have support from, I think it's 13 senators who wrote to the non-union automakers and said, please we expect you to remain neutral in any union organizing that you have.
All right. Thanks a lot, David, for covering all that in that detail. And I think everybody can hear me all right. So that's the new standard that we are really up against. As David indicated, some of this stuff is still pending, but quite frankly, once the general counsel threatens to make it happen, and given the current status of the board, I think almost all of those things are going to come into play. And we're already kind of forced to run our campaigns that way based on the fact that if that's what she says the law is going to be, if we run something counter to the law, we know we're going to get a ULP out of it and we're going to move forward. And the risk is a Cemex bargaining order now, if that's the case. So I want to start and kind of pivot from David's analysis to what this means, boots on the ground, so to speak, with labor relations, union avoidance, and with campaigns when we get into them. What you're looking at with this slide is the union win rates in elections for their last fiscal year as of August of this year. Over the course of that roughly 12-month period, the union's win rate had gone up to about 72%, culminating in just about 80% in August of last year. Some of these things that David mentioned had already kicked in. The big ones had not. The Cemex demand and rules with regard to unfair labor practices resulting in a bargaining order had not. Obviously, the ambush election rules had not kicked in, but they were starting to have an impact on how employers ran campaigns and managed campaigns. And the win rates, obviously, corresponding win rates for unions were really kind of challenging. That, to me, is only going to go up. In this new world order that we live in, that percent is going to continue. And if you think about it, 8 out of 10 petitions that are filed result in union victories. It's just going to be a challenging world that we're in, as David said, likely for the next 2 to 3 years. And what he meant by that, of course, is the way the board appointment cycles work. Even if there is a change in the presidency, so to speak, to pick any one of the Republicans, they would not have an opportunity to appoint a Republican majority in the time period with it for 2 years. So this is not something that's going to go away anytime soon. The only governor or change on this law is going to come if the Circuit Courts of Appeals reject it. And a lot of these cases are pending, but the board rules are going to go into effect unless and until that happens. So that's the challenge we're up against legally. What does that mean? And I want to put out there, since the Cemex case was decided back in early September, I personally have handled 4 union elections from start to finish. And they're not all exactly the same, but what you're looking at here is pretty much how they went down. We would tend to hear a little discontent. The unions are really placing even more of a premium on doing things as quietly as possible until we discover what's going on, and then doing a hard push to try and get to majority status before we can respond, so that then they can make this Cemex demand. That Cemex demand triggers 2 things, obviously, as David said. It puts us in a position where we've got to file potentially an RM petition. In all 4 of the elections that I've handled, that the unions have not waited the 14 days. They don't want to give us those extra 2 weeks to campaign, is what that's all about. And I think that's going to be even more likely in the ambush election rule. I think we're going to be getting these demand letters, and they're very quickly, within a day or 2, they're going to file their own petition to immediately trigger that 21-day moving forward. In most of the campaigns that I've been worked on so far, and obviously you can't talk about names here, the unions correspondingly, when they filed the demanding letter, fairly quickly filed ULPs. And 3 of the 4 that I've worked on, quite frankly, folks, that's what they did. They want to start the fear and the possibility in the employers' heads that, hey, you guys do anything more, and we're going to be getting a bargaining order. We're not going to have to worry about the outcome of the election. They will typically, and in all the cases I've had, play the elections out to see if they get a win anyway. But if they do not, what we're going to see is litigation being the conclusion of all these elections, not the vote count. The vote counts are almost just a step in the process the unions want to use. But what that does, and I highlighted it for everybody in red, is it really draws into focus how we have to be rethinking how we do campaigns going forward. And these 4 questions are going to come up more and more for all of you. I've done 300 to 400 campaigns over my career, and in virtually every one of them, we decided we were going to activate our supervisory team to go out and deliver messages, one-on-one, small groups, whatever it may be. Now, if we activate a fairly low-level supervisor, let's just say, and that individual goes out and says something inaccurate, illegal, based on the technicalities of the law, then we could get drug into court to get a demand letter or a bargaining order, regardless of really how significant that was. In the past, we would get a rerun election if we committed a ULP. We'd have to post a notice saying what we had done wrong and why that was wrong and that we won't do it again. And then employees would be allowed, with that curing of that ULP to go in and vote again. Now that's going to be gone. For most ULPs, as David's slide showed, we don't get that second chance unless they're truly very minor unfair labor practices. So do we activate supervisors to go out there and talk at all? Or do you sideline them out of the fear that a few missteps could result in a bargaining order, regardless of the outcome of an election? So you've got to make that really, really big strategic decision pretty early in the process, and it's going to affect your campaign outcomes. Similarly, regardless of how you do your campaigns, are you going to have people presenting written scripts and reading things to people, or are you going to do bullet points that they can ad lib and kind of expand a little bit upon your presentation that your lawyers or your campaign consultants may write for you? Are you only going to rely on videos? Are you only going to rely on written scripts? Are you only going to rely on websites and social media or electronic communications so that you can prove what you said and lock down and not do anything verbally? That's a strategic thing that's going to apply. Does that mean your campaign would be as effective? Absolutely not. Campaigns where you have a supervisor reading are going to be less effective than having the interaction and dialogue that a management person could do. Now, you can get around that by putting together a decent script, doing effective training, etc. Are you going to do captive audience meetings? There's a workaround around that the Starbucks case that David mentioned, I think, presents to us. And I have utilized that in the campaigns that I've worked on, where we start every meeting with something like a Miranda rights. Hey, guys, this is a meeting to talk about the union. If you don't want to stay, you're free to leave. If you choose to leave, nothing negative will happen to you. If you choose to stay, we're not going to give you any positive reward for staying. The reward is effectively the message you get to make a good decision. And give them those kind of rights up front. And hopefully that will work. The early indications, at least that Starbucks decision, do indicate that that might be beneficial. If the employees then stay, that's kind of an implicit acceptance of your message that they have the right to leave. But you got to decide, are you going to do those captive audience meetings? Similarly, given the broad definition of captive audience meetings, if you're going to give your supervisors messages to go out to give to employees, and that employee standing in an assembly line or at a desk or at a checkout counter or cooking food or whatever the case may be, and cannot walk away from the supervisor, that will be considered a captive audience meeting. So how are we going to deliver messages is going to be much, much different in every case than it used to be, given that they pulled our teeth. I personally believe that the nefarious nature of all of these rule changes is to get all employers to stand on the sidelines and do nothing. Because that is what happens. The stakes are so high if we're not doing anything. I don't agree that that's what we should be doing, but I think that's our goal. So this is the way it's worked, is you have that big evaluation. You're going to have to run campaigns differently. And I'm going to cover some of that as we get towards the end of our thing. As David said, the posters have to be up now within the new time period. All of my campaigns, by the way, were not under the ambush election rules, because my campaigns, the last one I had was right before Christmas. But the new ones, now we're going to have the posters up, both posting and email to people if we routinely use email to communicate with employees. We're going to have the new voter information, name, home address, mobile numbers, personal emails and stuff provided to the labor board, and at the same time to the union, so they can start blanketing our employees with texts, home visits, calls, etc. And then we're going to go through an election that, unless that's a very unusual circumstance, is going to be within 21 days. If the employer somehow, despite these new challenges that all came about in the last year, with the last one being December 26th, successfully wins an election, most elections aren't now going to end with that vote count, potentially an elections hearing and a rerun. Most election outcomes now, if the employer wins, are going to go into the unfair labor practice charge phase of the NLRB. And if you lose, and they prove some level of unfair labor practices that occurred after the union achieved a majority status card signed, then you're going to get a demand. You're going to get a bargaining order. You're not going to get a rerun election anymore. So what that really is going to mean, if you think of the several thousand elections that the labor board conducts every year, I think we're going to see a huge, huge backlog in the NLRB's litigation docket, because employers are going to have no choice. It's a fight to the death. It's no longer a fight to see whether you post a notice or do some other remedial order. It is a fight to determine, when these elections, whether you get a bargaining order and you are union because of what you did during that campaign. So in all four of the ones that I've had during the Cemex demand issue, since that came out in September, and now with the added wrinkle of the ambush elections, that's the process we're going to be going through, and we're going to have to evaluate. So what do we do? It's not all doom and gloom. Here are the facts, and I hope everybody can still see that because it changes color, that we have to address as part of our preparation, our union avoidance strategies, and ultimately, if we're targeted, our campaign strategies. Time is not going to be on our side. If the first thing we know about organizing activity is a demand letter followed by a petition, you've got 3 weeks to decide your fate. From a psychological standpoint, for those of us who have been through hundreds of these campaigns, a lot of times if they're so unhappy they're dealing with the union, you don't get them past the anger phase, the emotion phase, for at least 3 or 4 weeks. And that's why you can win a 5 to 6 week election much better than a 3 week, because you have time for anger and emotions to cool and facts can take over. So time's not going to be there, both from a legal and, quite frankly, a sociological standpoint. Unit issues are not going to be on our side. I think, well, I haven't seen this yet, but I think unions will go for a big broad issue in almost every case, a big unit in almost every case. If they fail, they will file a petition for a micro unit, try to win that election. And again, if you commit ULPs with regard to that micro unit that are proven, then they could get demand order just for that micro unit. So they're going to have the opportunity to both pick the units more and then change their campaign strategies based on what they have success getting cards signed to maximize their opportunity to get in. The message delivery process is not going to be on our side due to the likely loss of captive audience meetings. And given the fact that the labor board can often make their rules retroactive, almost all the election that lawyers and campaign specialists will be telling you to do, and you should be following those anyway. I think we've got a workaround. We've been doing workarounds on that by giving that kind of here are your rights to stay message up front. But there's no guarantee yet that that will be successful. Management delivery process will not be on our side. Will the significant nature of the penalties, if our management team, or if you utilize persuaders to provide your message for you? I will point out in the Cemex case, there was a persuader component to that were found to be part of the ULPs. So if you're going to, how you're going to deliver your message, whether it's internally with your own team or externally with experts, you got to make sure it's legal one way or another, because not, you get a demand. Fact number 5 is a practical fact that I'm going to point out, and I want to highlight how important that is. In the olden days of trying these cases, you could have testimonial, and then it'd come down to the credibility of witness as to what somebody said in a meeting or on the shop floor or in the cafeteria. In this day and age, in most states where they are single consent states with regard to covert or secret recordings, you do not know if somebody's got a camera. And in almost every instance, they're recording things. So the matter of proof in a ULP that's going to tie our hands and potentially result in a bargaining order is going to be much more difficult by the fact that these cameras and mobile phones are so prevalent anymore. I cannot tell you how often this is popping up in ULP cases, in employment litigation, whatever the case may be. So that increases our risk here, because the matter of proof as to whether or not something was or was not said is going to be more difficult to overcome. So fact number 6, campaigns are going to have to be nearly perfect. We cannot take risks. We cannot say things, as David pointed out. And that's what fact number 7 is all about, is we can't have nuanced messages like maybe you can't deal directly with your employees anymore. We got to very accurately state what that specific section of the National Labor Relations Act that David mentioned on what the employee's ultimate rights are to still deal with employers, even if they're unionized. We got to make sure that you really accurately state that if you're going to capitalize on that message. I will tell you, every campaign I work on, we capitalize on that message. The one thing that we like to point out changes with you go union, it isn't wages go up, it isn't benefits go up. It is that the relationship changes between you and your employees. We believe that's bad. Union believes that's good, to get rid of favoritism and give them the opportunity to speak for employees. But that message has to be stated spot on now to be used. So we really have to focus on making sure that wording is correct. That is not a message I would ever trust an entry-level supervisor to verbalize to employees. So delivery of that message has to be in a scripted, written, electronic kind of format. And ultimately, fact number 8 is we've got to be prepared for a Cemex demand. Although I haven't personally seen it, and I'm unaware of talking with anybody that trap has been utilized, it's still part of the Cemex case. And that is, if they make a demand and we don't reply by filing an RM petition within 14 days, that unit, whatever it was described by the union, is now union. So we can't let that 14-day period slide if the unions are inclined to do it. And I think at some point we're going to start seeing some of them taking a chance, particularly if you imagine a multi-location company cannot do perfect training, for example, maybe their managers at the different locations. They might take a chance to see if they can get one of these to slip through and get recognition that way without having to go through a campaign. So overall, your avoidance philosophies, how you run a campaign, and the message that you provide has to be rethought and reanalyzed and updated in light of these shifting standards that we know are going to be in place for at least 26 through pretty close to 27 when we start looking out, we're already into 2024. So what does this mean? And at the end of the materials, they're not stuff that David and I are going to cover today. The stuff that I'm talking about right now is kind of laid out in a more detailed 7-step thing. It's available, as Jennifer said, that you'll be having it through your materials. But the avoidance premium that we always talk about is key. Anything we can do to increase employee engagement, increase employee satisfaction through rewards, incentives, lunches, fair treatment, obviously, is what it's all about, is just absolutely critical. And I call it putting the human and human resources, the employee and employee relations. We've got to really refocus as a workforce. The analogy I always use is it's the weakest zebra that the hyenas pick off on the Serengeti in Africa. We don't want to be the weakest zebra. We know they're coming for us. Organizing is way up, and it's going to increase now with the ambush elections. We need to harden ourselves so that we're the tougher zebra in the herd and let the hyenas go after other people. Employee engagement surveys to see how they stand. I think we need to kind of see if those are effective. Wage benefit surveys are critical. In this day and age, historically, people would tell you that you lose a campaign not based on wages, you lose it based on treatment. I think that's historical now and maybe not the future. The new generation is much more interested in how much they're getting paid and how much time off they get, and a little less on their treatment. So I think we got to make sure we are competitive. Are we hiring and training people effectively? Do we have good, strong employee ambassadors in our organization? And typically that would be non-supervisors who talk to employees about why we're a good place to work. Do we have strong orientation procedures? Do we have effective conflict resolution? Do we have good and legal employee committees maybe to deal with things like safety or workplace issues? A truly open door. Have we reviewed our handbook and policies to make sure they're legal under the new Cycle decision that effectively return to the way they worked under the Obama board? That is critical right now. Our goal out of all this is based on what we use in the industry as the 20-60-20 rule. And that is 20% of the employees are always going to be pro-union just based on family history or whatever. 20% are likely going to hate unions and never consider organizing based on similar factors. It's the 60% and mostly in the middle that we have to make sure we're able to influence. By activating things like employee ambassadors and doing these things, we set tripwires with our 20% that are for us to help keep people happy and satisfied. And more importantly, let us know if we're dealing with discontent so we can start responding. So those kind of things are critical. And good HR and good employee relations tactics are fundamental, as well as money. It's going to cost more money to get these kind of things in your budget. So starting in 2024 now, those are important to do. The other thing we have to do from an avoidance standpoint, and we preach this all the time, but the premium is even more on this than it ever has been. Making sure we've got good supervisors with interpersonal skills who treat employees fairly, who don't just know how to do the work. Training those supervisors on how to be a good supervisor. I tell you, I spend a lot of time with clients, and I think it's critical, and I think it's important to give good training on the law, tips, union avoidance, that kind of stuff. I am not an expert and rely on good HR professionals to do this, to train management on how to be a good supervisor, how to treat employees fairly, how to document fairly, how to promote fairly, how to review fairly. those are the things that lead a lot of times to discontent that we can take care of if we've got good supervisors. Part of that is evaluating the supervisors on how they're doing when we train them that way. HR and upper management obviously leading by example. Management by walking around has always been a critical thing. One of the first things we always do in a campaign, I do personally at least, is my first question when I'm talking to people about how we're going to staff a campaign and respond is, what do people think of our leaders? Do they like the plant manager? Do they like the office manager? Do they like human resources? Is that person known to everybody and out on the shop floor? Because if that person is not a known entity, then we fight the uphill battle of building the trust in the first place before we can even develop and build the message. Using your gossipers, complainers, and leaders. Most of you think people who gossip all the time are an albatross around your neck. I love them because they can't keep their mouths shut if there's union activity going on, and we learned about it earlier. So making sure that your supervisors and HR just spend some time talking to those people. Similarly, people that complain all the time. They'll tell you about things, and we'll kind of have our canary in the mine. Making that 20% that are workforce leaders that are never going to be union, enable them and empower them to monitor and get information to us. That's a key part of the avoidance programs that you would need to be doing in light of these new timelines and these new risks. Monitoring. Is there union activity in the area? If you're a hybrid employer that's partial union, partial not, how do our CBAs and how do our bargaining affect our places that are non-union? And what are we going to do to make sure we keep things kind of in lockstep or be able to message why they're different? Monitoring industry activity. UAW has made no qualms about the fact that their total goal is to leverage what they consider to be big contract gains in the most recent round of bargaining with the big three by expanding it out to anybody that would consider the UAW. Similarly, Teamsters are saying the thing about the UPS contracts that they negotiated. They're touting these, what they claim to be massive increases. And we got to be prepared for that. That message has been used against me in campaigns I've worked on, both with the Teamsters and with the UAW. Monitoring social media, that's often one of our key canaries in the mine. And just having something on your system or somebody in your PR department typically that monitors anything that's being said about the company and gets a trigger if there's a lot of social media activity going on. That kind of lets us know because unions are using a lot of social media in their organizing. All of these are critical facts. Preparation. What are we going to do with regard to our training of our team? Focus on causing discontent. And again, we're not going to have time in a 1-hour seminar to cover all this, but all of this is detailed in the final slides, and you can get more detail on it. How do we train employees to know if there are signs of discontent pre-union activity? So that we can start responding to that issue before we have to respond to the U word. Make sure we've got a reporting structure so that we can respond quickly. Our goal should always be now to get active before they hit 50%. One thing that is clear about the Cemex and the ambush elections is if we can keep them below the 50% threshold, that gives us more opportunities and, quite frankly, less risks with regard to our campaign strategies. If they can't demonstrate a majority, they cannot get a Cemex bargaining order. That's dependent upon them being able to show a majority. If we think they filed a petition because they didn't have a majority and they never made a demand, we might have more flexibility in taking some risks in our campaign. So the early understanding of what's going on, early signs of discontent, a good reporting structure to make sure we can learn and start responding better. I use my code green, yellow, orange, and red kind of thought. And again, that's in the materials on how we can kind of look at this in a way to address things, the right message at the right time. Train your management, get them ready. We have to have every manager who, as David pointed out, could be presented with the Cemex demand, know what to do with it. Anybody who's an agent of the employer, according to Ms. Abruzzo, could be one that could receive this demand. So we've got to make sure if they get it, whether it's an email, in a letter, and she even said it could be verbally provided to the supervisor, which is a level of insanity I never thought I would deal with the labor board. And I'm used to a pretty high level of insanity. That's just crazy. So we got to make sure our management team knows if somebody does demand recognition, they can't just say, forget about that, I'm going to ignore it. They got to pass that on to somebody who can make a decision on it. Two very clear basic messages that we can have anybody say that at least gets something started and allows us to provide. Do good training that really gets our supervisors knowing they can't just go out and say crazy things potentially that could result in a demand, bargaining demand and a bargaining order ultimately. These are some of the preparations we need to do. Review your high risk. Do you have areas of the country, areas of your company, areas of a facility that could be involved? Do you have joint employers with others that could drag you in? Who is a supervisor? As David mentioned, this law excludes supervisors from being covered. So knowing who is a supervisor and who would be on our team to help us or our team to hurt us by doing something illegal that could bind us, that's out there. Do the simple things. What's your facility? What kind of security do we have to make sure people can't get into our property? Social media tracking, like I talked about. Rejuvenate your internal or external perception surveys of issues that could be leading it. Get your external partner preparation in place. Are you going to have persuaders involved? There's some great persuaders out there. I use them still regularly in my campaigns. Are you going to use local leaders? I learned with a lot of campaigns in the South that keeping the religious community on your side can be very helpful in a campaign. We used to host a minister for a day where we would have all the local ministers come in, have lunch, tour the plant, get to know the place, and get them on our side to the extent we can. Our content providers, are we going to use videos? Which company? Projections, IRI, and these aren't paid for plugs, by the way, but companies I work with. Are we going to have these folks have videos made, whether it's a stock one or a customer tailor one? Things that we need to do. Do we want to have these kind of bigger picture things? I've got organizations now that are addressing the union issue in orientation. They are starting it up front with new employees saying they're doing it. And I know various companies that do a short video that you can show. I've drafted and worked with companies to develop a custom one for certain companies, both in healthcare and in restaurant and other industry and manufacturing industries. What can we do? Do we think we have to take our message to employees before we ever get targeted now? These are all things we got to be thinking about. What's our early response? Who is going to lead our SWAT or our ready response team? How are we going to address our green, yellow, orange, red protocols? Which, by the way, if you're following that kind of green, yellow, orange, red, it's not just a union avoidance thing. It does help you see if there are other issues in the plant that might be going on, harassment, discrimination, those kind of concerns. Revise and review those of you that have prepared early response protocols and consider adding things in there like that. Hey, you're not captive. If you want to leave this meeting, you can do that. Who are going to be your standard bearers to deliver messages? Prepare your early messages to say who we are. And all of these things, by the way, can be incorporated into your general training programs that you do for your employees on labor relations. Who's the persuaders we're going to use? Are we going to limit our campaigns down here at the bottom to management at the top level? And we're going to tell the lower level, you don't say a word about this. Are we even going to go a step further and only limit it to videos or written content? All these things can be thought of in advance that will help you prepare if you've got discontent, if you're getting situations where there's organizing going on so that you can start responding quickly, and that will get you ready to go if either those things don't happen and you end up with a demand letter and a 21-day election cycle coming at you. So that's what David and I wanted to try and cover in just the hour that we had while we're talking. And as we've said, we'll check the chat when we're done here. And I think we can open this up for verbal comments as well to have a conversation. We are truly in a new world where the deck is stacked against us. And it's not just the normal things that are stacked against us. It's the remedies if we do something wrong. Or we're union just by virtue of the fact potentially that we said something wrong. And that is a very, very brutal standard to try and deal with now. And it's even more brutal if you're caught off guard and the first thing you hear or see is you get a demand letter from a union that drops into your email or drops into your mail, or that they bring to you and hand you personally. So what are we going to do? Harden your targets as much as you can right now. Do your best things you can as human resources and employee relations professionals to keep people happy. Do training where you need to on good supervisory skills and labor relations. Check your handbooks and other materials. Those can be ULPs in a campaign too, if they say things that would violate the National Labor Relations Act. Make sure your team is ready to respond if they do get a Cemex demand letter. I want to emphasize the 4 I've had since we got it, they did not wait the 14 days, and I think that's likely to be what happens most of the time. But we still can't let that slip. They got to know if it happens that we let it respond or respond within 14 days. Those RM petitions are fairly easy to prepare. I've prepared a couple in anticipation that they did not go ahead and file their RC petition, but you don't want to get close to 14 days and then have to file. Look at yourselves. You know yourselves better than any outside guys like me or David could you. What are your strengths and weaknesses that could be capitalized to make a campaign card signing effort move quickly? Do you have tripwires and policies and procedures in place that would slow it down? Because right now we win this fight if we don't get them to 50% and we can go through a normal kind of election process. If they get to 50%, we are really, really at risk in virtually anything we do under these new rules. Get that stuff ready. Some of you, and I know I work with a lot of clients, we've got their basic first 2 weeks of a campaign in a draft format ready to go. Talked about the strategy, the videos, persuaders, whoever we're going to use or not use. And we kind of know that if we get a demand letter, we've got a process we're going to follow. We don't have to start from scratch. We've got 90% of it done or 80%, pick your number, and we're ready to go. This is under these new rules, and truly this is the case. And I don't want to end on a political note here, but President Biden has said he wants to go down in history as the most pro-union labor president ever. Those are his words, not mine. This labor board and these new rules that we've got are how that is going to be brought into action. So we are likely to see record-breaking union organizing in 2024. We are likely to see record-breaking employer losses in 2024. So we need to act now to try and get up to speed and do the things we can to harden our target and be the toughest zebra in the herd. That's the goal. So with that in mind, I'm going to end with these words of Yogi Berra, and then I'm going to put the QR codes up, or the numbers up, for those of you that are seeking to get this certified from an HR standpoint. And I'm going to just very quickly show you what's in the other slides, and then David and I will kick this over and start looking at your questions that we've got out there. Here's the numbers, and I'll leave that slide up there for a second so everybody can write those down, and then I will revisit that as we're going through the Q&A to make sure that you've got that on your things as well. And then this is David and I's contact. This will all be in that's my mobile number. David, I think that's your mobile number as well. So you can reach out to us either electronically or by phone to go forward. And if you need to reach out to us, you can do that. The 7-step prob thing that I've preached to my clients for years is all this stuff you're seeing here in much more detail that I've referenced. So that stuff is available to everybody going forward. And for now, I think I'm putting the slide back up so you can see it. I am going to scroll back through the Q&A. Jennifer, is there a way we can open it up for verbal questions and comments as well while I'm doing that, or how is the process to end here? I understand folks have to drop off, totally get it, but we will try and answer some questions now verbally and in writing.
Yeah, we cannot open it up for people to speak, but if you want to read through their questions and provide an answer whenever you're able to.
Yeah, okay. Well, I will start doing that. And David, I'll read them to you. I don't know if you can see them as they're popping up as well. What is your best advice regarding cameras and recordings? Should the employer use recordings and disclose that the meeting is being recorded? Discuss that the meeting will be recorded, similar to the Miranda advice you gave to captive audience meetings. That is going to be a case-by-case decision, but I have got some employers that are very much considering that. And I've talked about it with some of my clients in the campaigns that I've been involved with. If we tell everybody, look, that we're going to have this recorded so that nobody can accuse me of saying something I didn't, so be aware this is going to be recorded, it adds to our legal defenses, if you will. My fear of that is that quells or quenches or prevents employees from giving us any feedback during the meeting because they're afraid to say something. And in a campaign setting, getting that feedback is often vital to allow us to tailor our message to see how our message is effective or not. So I can't in a blanket way say, yes, do that, or no, don't do that, because I think it's a case-by-case analysis. And I think you'd want to double check the state that you are in to make sure that's sufficient to get dual consent if you're in a single consent state. But it is something that I have very much thought about in these campaigns, and it's a blessing and a curse. As long as we make sure we say things legally and we're recording it, it's great. If we cross the line and for some reason we say something that's not legal, we're going to be hoisted on our own petard, as the saying goes, and our violations will be proven by our own recording. So I think you got to discuss that with whoever you're working with when you're doing campaigns on how you would do that. Let's go down to the next questions.
And Tim, can I add one thing on
Oh,
that?
please do, David. Jump in while I'm looking at the next question.
Well, I was just going to say, yeah, specifically for meetings, I think what you said is exactly right. I just wanted to mention that the general counsel put out either a GC memo or an advice memo that basically attacked employer efforts at recording and use of algorithms on computers that monitor employee activity. And the logical conclusion of it that I came to was even security cameras out on your parking lot might be, in the general counsel's view, deterring union activity and therefore an unfair labor practice themselves. So as to cameras and recording more broadly, different than just meetings, it's something to think very carefully about. And I think probably safety arguments that you have to have it for safety should win the day. For instance, food security. I was involved in a case where they had video cameras on every single production line in a food facility because it was required by federal law and regulations for the food safety. Outside of that, I think it's a little unpredictable what this general counsel might allege is unlawful interference.
Totally agree. Totally agree. Next question: is there a group or list of industries in which the union organizers are currently focused? I have no doubt that if you're in the automotive, whether it's assembly, one of the transplants, as the unions call them, or in the OEM world, you're non-union, the UAW is definitely got you in their targets. And unfortunately, they've got a pretty good story to tell right now when it comes to what they claim they achieved through the latest round of Big Three bargaining. So there's no doubt if you're automotive, this is nothing new. It's something I've been dealing with for many years. Healthcare has been a focus of union organizing, more in the big city areas, if you will, and on the coasts or big cities like Chicago, than maybe outside of that world. But healthcare is still a target. I think the restaurant industry is one the unions have been looking at for some time and may actually turn some, rather than just protest efforts towards. So I could see that developing. Logistics, of course, with the UPS contract, and those are out there. I wish I could narrow it down more than that, but because we've got unions in every industry, I think we with these new rules, I don't know that any industry is going to be worse than any others. These new rules are going to make it so much easier for unions to do it that everybody, I think, has to look at their new threshold. Please put the HRCI number back up. Got that? Got the HRC. Will we get a copy of the 7 steps documentation from the end of the slide presentation? Yes, the entire slide presentation will be available. Jennifer, I don't know how we're doing that. If you want to explain that process.
Yes, we will be sending a copy of the PowerPoint and a recording of this webinar by tomorrow morning once the recording has been uploaded directly to your email.
Perfect. Perfect. So yes, all of that information that we're seeing today and all of this stuff that goes over kind of 7 steps to start hardening your target is going to be emailed to you. It sounds like it's part of this presentation, even though we didn't discuss it. I will say my philosophy, and I'll end right now because I think that's all the questions. My philosophy with clients is almost always focused on this slide you're looking at now. What can we do to be a great RHR person and a great company so we never get past code green? If we do get past code green and employees are complaining about certain issues, what can we do to address those issues without raising the U word ourselves? Code orange is when we start getting discontent and union talk. What can we do? And code red, obviously, is when we get card signing going on. But our goal is obviously to keep the temperature as unthreatening as possible throughout all of our relations, knowing that in this new world, we're going to get targeted anyway. But that's my final comment that I would have for everybody. I don't want to sound like the sky is falling. David, I think, very succinctly highlighted that the fact the sky is in part falling, and the law is not going to be in our favor for a couple of years. And so we're going to have to do what we can ourselves internally to deal with these things and get through this couple of years, perhaps, if not longer. I mean, we're looking at 2 or up to at least 6 years of this kind of activity in possibility. I won't say in all likelihood. So whatever we can do to get ready is going to be the goal. So I do thank everybody that's attended and stuck with us. David, I'm going to pass it over to you if you got any final comments. Well, and we will hopefully not have to chat again with you guys about this soon. And if you do, happy to help at any time.
Right. And well, there was one more question, Tim, that I saw that came in at the end that I'll try to address, and then you could add anything you want to. Someone asked, could we explain more about a ULP? So one thing about labor law is we use a lot of acronyms, and ULP is one of them. Charge is another. Decert petition, RM petition, RC. We use it unfairly for the lay people, but ULP is unfair labor practice. The National Labor Relations Board does not have what I would call self-affecting jurisdiction. It has to get something put before it can go to work. And so it has representation case jurisdiction when petitions and other things like petitions get filed with it. And it has jurisdiction when an unfair labor practice charge gets filed. Unfair labor practice charges, in theory, can be filed against employers or unions. And employer doesn't need to be your own employer, but it's essentially, there are various enumerated provisions under one section of the National Labor Relations Act that deal with various things employers cannot do, and those would be unfair labor practices. And so today we talked mainly about interference. There's also one on discrimination. There's one on unlawful support of unions. In other words, you can't have a company union. You can't set up a company committee that effectively is the union. But today we were talking about interference, which is normally, you may have heard some discussions in training seminars about you can't interrogate, spy, promise. What's the last one, Tim? I'm blanking out. Threaten. So, and those are, at least in the current view, consider those very expansively interpreted. The law doesn't say any of those things, but for instance, to threaten could be implicit that if you mention, there was a recent case, I think, involved Amazon that involved the persuader who's good, and they made some statements about historical fact. And the board, at least in that case, at least in ALJ, the board found that those his pointing out that history was itself threatening to employees. And so that's what an unfair labor practice is. It starts with a charge by either typically an employee or a union, but it could be anyone, and it could be on behalf of themselves or other people. Tim, do you have anything to add to that?
No, I think that's great. We did have one question that I missed, and I apologize. I just didn't scroll down all the way through it. It's from someone who has an operation that has like multiple 70, in this case, locations around the country, it sounds like. And the question was pros and cons of utilizing persuaders or others to do it in lieu of flying management around, like upper management around. But you are kind of one of the more difficult entities to develop an effective campaign for. And I got a lot of it, quite a lot in the quick service restaurant and other industry where we've got dozens of locations, say, around. And that is an option. I think I'd love to have a chat with you. If we currently work with you, obviously the attorney you work with, but if you want to just talk to David or I would be happy to do it. But that's tough. For organizations like yours, I've had things where we record the upper management delivering a message, so that can be shown at any minute at one of the 70 locations. And I think that's effective. We've had Zoom presentations where we've done it, where you can pull people in, or where you can have the supervisor of the manager of that location pull people into a Zoom presentation. Not as good, obviously, as face-to-face, but better than nothing. All of those are options in addition to doing the persuaders, because the persuaders also will be fairly costly if you're trying to get 50 locations at once. That's something that can't be done immediately. So I think those are options. Persuaders doing it in lieu of flying out upper management is one option. Recording a message on our labor relations philosophy and why unions are not necessary is another. Recording somebody delivering a card talk on why we think you shouldn't sign a union card, or using one of the stock videos you can get from these companies that do it. And there are some really good ones out there. All of those should be on the table for an organization like yourself. I will say this, at the end of the day, I found the very best message to be as high up as you can go, delivering a heartfelt reason why we think it's bad for the business. So all of those tools can be deployed. I don't know that you would ever want to use those in lieu of that reach out to do it. Starbucks, for example, did use high-level people, and they kind of flew them around. They're not a client of ours. I've never done their work, so I'm not giving you any insider information. And that in their, as that their numbers would indicate, worked in a lot of instances. it didn't work in all of them, just because when you got 300 or 400 petitions pending, it gets hard to do that. So I think, again, I'd be happy to talk to you. Shoot me an email or shoot David an email. I'd love to kind of brainstorm with you on what your strategies might be, but everything you suggested in your little brief chat here should be on the table for consideration. No, I apologize. I think that is the last one. And I know we've kept folks, I know everybody can drop off if they want to, but we've gone about 15 minutes over. I, from a heartfelt standpoint, thank all of you for joining us, and do mean what I say. If you drop something in the email that you want to ask David or myself, you're not going to get a bill. We're not going to say, oh, geez, you're going to start billing you for this. We do want to help you out. We know these are complex rules that we try to cover in an hour, and we're more than happy to try and pitch in and help out with what you're dealing with. So with that being said, I think we're done, David. Jennifer, any final comments before we end?
That's all. Thank you all for joining us today. We'll now end the webinar.
Thank you much.
Take care.